Showing on Law Weekly today, we continue our focus on the non-assets declaration by the Chief Justice of Nigeria, Justice Walter Onnoghen. Also, we bring you highlights from the opening of the 8th Admiralty Law Seminar organized for judges. Plus, lawyers react to the withdrawal of the presidential candidates for the Allied Congress Party of Nigeria, ACPN, Obi Ezekwesili, from the presidential race. Hello and welcome to this week's episode of Law Weekly. I'm Victoria Ido. Now to the issue of the day. On Saturday, January 12th, the news broke that the Chief Justice of Nigeria, Justice Walter Onnoghen, will be arraigned before the Code of Conduct Tribunal for failing to declare his asset as prescribed by law. A lot of legal fireworks erupted, and by Monday, the 21st of January, the chairman of the Code of Conduct Tribunal, Danladi Umar, had been served with an interim order and a hearing notice seeking to restrain the CCT from persecuting the CJN. By the 22nd, the chairman of the Code of Conduct Tribunal insisted on going ahead with the trial, saying the restraining orders issued by the National Industrial Court, the Federal High Court, and an Abuja High Court is not binding on the tribunal. On Thursday, the 24th of January, the Court of Appeal barred the CCT from proceeding with hearing the suit against the CJN until after the appeal court decides on whether or not the CCT has the jurisdiction to hear the suit, which happens on Wednesday, the 30th of January. By Friday, the 25th of January, the story had changed. As it stands, President Muhammadu Buhari has suspended the Chief Justice of Nigeria, Justice Walter Onnoghen, and has sworn in Justice Ibrahim Tanko Muhammad as the acting Chief Justice of Nigeria. Justice Muhammad hails from Bauchi State, and he is the most senior judge in the Supreme Court after Justice Onnoghen. The suspension of Justice Onnoghen is pending the completion of his trial. The federal government has asked Justice Onnoghen to step aside over the allegations of false assets declaration at the Code of Conduct Bureau. The president said he acted on the request of the Code of Conduct Tribunal.
Nigeria is a constitutional democracy, and no one must be or be seen to be above the law. Unfortunately, the drama around the trial of the Chief Justice of Nigeria has challenged that pillar of justice in the perception of the ordinary man on the street. For it is certain that no ordinary Nigerian can get the swift and sufficient treatment justice has enjoyed from his subordinates and friars in our judicature. In the midst of all these distracting events, the essential question of whether the accused Chief Justice actually has a case to answer has been lost in the squabble over the form and nature of his trial. This should not be so. If justice cannot be done, and clearly seen to be done, society itself is at risk of the most unimaginable chaos. It is no secret that this government is dissatisfied with the alarming rate in which the Supreme Court of Nigeria, under the oversight of Justice Walter, has serially set free persons accused of the most dire acts of corruption, often on mere technicalities, and after quite a number of them have been convicted by the trial and appellate courts.
We had a chat with a senior advocate of Nigeria, Norrisin Quakers, on these issues. First, he gives us his thought on the issues surrounding the CJN and the CCT. Thank you very much for obliging us again. Now, what were your initial thoughts when you heard about the suspension of the CJN?
First, I'll say this to you. I wasn't surprised that it has happened. But the general impression out there is that it is the president that suspended the CJN. Well, that's far from the truth. What has transpired really is that an order was obtained before the Code of Conduct Tribunal, an interim order for his suspension, or you could use the word, in fact, the words of the order is that he should step aside and that the president was directed to swear in the most senior judge in the Supreme Court hierarchy. Now that is covered by section 3213 of the Constitution, sub 4, to the effect that whenever a vacancy occurs in that office, in relation to the office of the CJN, the president, by virtue of sub 4 of that section 231, sub 4, is empowered to swear in the next most senior judge. So what has happened now is compliance with constitutional provision where a vacancy has occurred, because there's an order from the tribunal and the president has acted on that order of the tribunal. It was not as if the president was the one that suspended the Chief Justice of Nigeria. It wasn't the president that suspended, because that will also be in itself a constitutional hierarchy, a constitutional crisis, a constitutional conflict, because the president, as the executive, cannot encroach on the turf of the judiciary, because the head of the judiciary happens to be the Chief Justice of the Republic.
Was due process followed?
Certainly not. What we already have in itself has also created constitutional crisis. Under section 292 of the Constitution of the Federal Republic of Nigeria, the only way a justice of the Supreme Court in the caliber of the Chief Justice of Nigeria can be removed is by 2/3 majority of the Senate. Mind you, as to whether the Code of Conduct Tribunal can sit and preside over the person of the Chief Justice of Nigeria, the question has actually been laid to rest. I recall that there is a preliminary objection that is pending before the Code of Conduct Tribunal as regards its jurisdiction. There was also an order that was made by the Supervisory Court in relation to the Code of Conduct Tribunal, which is the Court of Appeal, ordering it to stay proceedings pending the appeal to it. Now, in the pendency of that order, an interim order was obtained, which the President has acted upon by swearing in the second in command, the Vice Chairman of the National Judicial Council, Federal Judicial Council, and so that's where we have found ourselves.
But is this, since the appeal court has already given a ruling staying proceedings at the CCT, is this not flouting the orders of the appeal court?
Clearly, you see, we're in very strange times. If my memory is not failing me, this issue has been laid to rest. When the court disobeys an order of a superior court, it is seen as judicial rascality or recklessness. And so what we have seen here is the CCT is aware of the order of the Court of Appeal, directing it to stay proceeding before it. And an application for interim order was filed before it. It heard it and granted it as prayed. That is what one can describe as judicial suicide. But as to whether whether it can be reversed with what is on ground, you now have a political solution to a legal problem.
How should it have been done?
One is to submit himself to the National Judicial Council, which is what you consider to be honorable, by saying to them, an allegation has been made against me. I've also responded by saying that, oh, I actually forgot, I didn't know, and the allegation happens to be in violation of the Code of Conduct for judicial officers. So therefore, I need to submit myself to investigation and then to hearing. In order not to desecrate my office, I want to step aside. That's one level of looking at it. The other level again is an allegation of this magnitude following the decision of the Court of Appeal in FRN against Ngajiwa is to be forwarded to the NJC. The NJC will now constitute a panel to look into it, to look at the breach, and now to decide whether the CJN should be advised to step aside or step down, or recommendation will be made for his removal from office. Now, in sitting, because he is the chairman of the various judicial bodies or organs, Federal Judicial Service Commission, National Judicial Council, and a number of other institutions. On the day of the sitting, he will be advised to step down. The vice chairman will now step in. Mind you, it's a body of both lawyers and non-lawyers. So they look into the allegation. If it is found credible, recommendations will be made for the president for his removal. The president in turn will forward the recommendation of the National Judicial Council to the Senate so that it could have 2/3 majority of the Senate for the removal of the CJN. And that is a constitutional provision. And because we operate constitutional democracy, that is what is expected to have been done and not what we're seeing now. This is making a mockery of our democracy and is an insult on our common intelligence and our common heritage, and that we cannot encourage.
Is there anything the judiciary can do at this time?
Unfortunately, because you also have a divided judiciary, you also have a judiciary that is not speaking one voice, a judiciary that is not also united. So that for me, all I can say is there's nothing the judiciary can do as it is now, except the acting Chief Justice of Nigeria decides to embrace or come up with a policy that will bring the judiciary under the umbrella of some autonomy or independence. Except that happens, I don't see how the judiciary can speak with one voice.
Now, I know that when the story broke, a lot of senior advocates of Nigeria went to the CCT with the CJN. Could they have advised him differently?
No. For me, it is not even a question of appearing in court for the purpose of identifying with this Chief Justice in solidarity. It's a question of preserving the institution. It's a question of protecting the office of the Chief Justice of Nigeria. Now, and I think that's why the senior advocates appeared in the matter, that look, encouraging the government to follow due process. And if the Constitution, in its wisdom, has given some immunity in quotes in terms of if for any reason the CJN is to be removed, there's a provision for his removal in the Constitution. And that's the essence of the senior advocates who went to court, that look, follow due process. This is what the law is. Anything outside of due process will now be at the whims and caprice of the executive, and then it will not be an abuse of the hierarchical structure of governance, because the Chief Justice of Nigeria represents an arm of government, and so he should not be treated with scorn, with levity, or his office should not be denigrated.